Custody fights are often the most emotional and contested part of a divorce.
Usually the first thing that parents will ask me is when they meet with me is, hey, how is this going to work with my children? Am I going to see them every day?
I cannot imagine anything more anxiety provoking than the thought of not seeing my kids every day. It's important that you understand what a contested custody case looks like and what factors a court will consider in determining which parent has custody of the children. How do you prepare your clients? What can you tell them about factors that the court might consider in making those really important determinations?
Most of the time, these parents don't know that there are factors that the courts consider. So that's a good opportunity for us to kind of talk about, well, these are the things that the court's going to look at. Some of the factors include alcohol abuse, other substance abuse. Age of child is a big one, right? How old the child is, how young the child is. Does one person work third shift? Does the other person travel a lot for work? So these are all factors that we'll sit down and we'll talk about and see if they are factors that are pertinent to this particular case, and then we can start kind of creating a baseline understanding of what a custody order might look like for this particular individual.
People come to us all the time wanting to know, am I going to end up with custody of my kids? Is the other parent going to end up with custody of the kids? And the reality is, it's not a simple either-or question. There's so much involved in the ultimate determination of custody and placement of your children. So let's talk more about that and get you some answers. I think the way you just described it, of this very wide range of considerations that might be taken into consideration by the court, that all plays into it. I mean, in Wisconsin, is there any sort of favorability of mom versus dad?
I get that question a lot. Hey, is Wisconsin a woman's state? Do we not favor dads here? And that's not true. Okay, so Wisconsin is a great state in the sense that they look at both parents equally. So there is no mom's going to get favored, dad's going to get favored. They want to look at your case individually and see, okay, what are the factors, the circumstances involving you, the mom, the dad, the child, and then go through those factors that I listed to see, okay, what's now in the child's best interest? How can we devise a custody arrangement that fits not only the needs of the child, but also the needs of the parents, and really looks at each person's individual scenario. But to answer your question directly, no, there really isn't any kind of favoritism here in our state.
So I'm hearing you say it's not an either or. Neither parent has the upper hand from the onset. Doesn't mean that after considering those factors that one parent may be considered to be perhaps more of a primary caregiver or have an upper hand in the custody battle, but there's not that kind of starting point presumption. That's what I'm hearing you say. If they can't reach an agreement, tell me what that experience is like for the clients. Like procedurally, what do they go through?
The first part is you want to make sure that you get a good experienced attorney who deals with these things. The next step really is to start working on settlements, right? So it'll be the clients and the other party and their attorney if they have one, and then the client's attorney, and we sit down and we see if we can work on an agreement to encompass custody and placement and all the terms to create this arrangement. If that doesn't work, then the next step would be to go to what's called mediation. And mediation is a fantastic source where the parties go and they meet with a third-party mediator, somebody who is not vested in the case at all. They don't know anything about the case, and their job is to kind of help you facilitate an agreement that maybe you weren't able to do prior, or finish up some of the loose ends of the agreement you may have already kind of reached. If that doesn't succeed, then the next step is to appoint a guardian ad litem, also called a GAL. Right, and the guardian ad litem comes in, and they are appointed by the court, and they are now involved in the case, and they conduct investigations and meet with the parties and maybe the child, and they will put together a report, if you will, that kind of recommends what they believe would be the best arrangement. And if that doesn't conclude it, then the matter would go to trial, wherein a judge would now make a decision. And I think what's important to note here, Holly, is that throughout the entire process, the further you get away from that initial settlement, the less control you have. So you start to lose control. Once a guardian ad litem gets appointed, you lose a little bit of control there. And once you get to the phase where there's a judge involved, you've essentially lost all control, because now the decision is going to be made by a judge, and he doesn't know you from anybody else, right? Doesn't know your child, and basically he or she is just taking the information provided by the attorneys and by the guardian ad litem and making an order. So that's why what's really important is to make sure you get a good, well-experienced attorney who's going to help you settle the matter from the get-go versus having to go all the way to that point where, like I said, you start to lose that control.
It's crucial that you understand the process and what your case will actually involve so that you can make really good choices, well-informed choices, being led by your attorney the whole way through so that you can retain control and understand at what points you may actually start to lose control. How can you avoid a contested custody dispute and control the outcome of your case? I think it's fair to say that most people are not excited at the prospect of a long, drawn-out custody battle. So how can clients avoid that?
Well, I think to start, you have to hire good counsel, hire a good attorney, and really heed their advice. This is something that they do for a living. They experience this all the time. So you might come in and you might be really, headstrong about what your position is, but you have to, understand that you're meeting with an attorney for the reasons that you're looking to get guidance. And so it's important to hire a good, experienced attorney, and then not just hire them, but also heed their advice moving forward.
And do you provide the client with information on, any sort of presumption in the law?
Yeah, great question. And we have that brought to our attention a lot. The client's going to say, well, what's going to happen? In other words, what they're asking is, what is the presumption? What's the court going to assume? And so there is a presumption in Wisconsin for both custody and placement. For custody, the law presumes that each parent gets 50-50 custody, that both parents start from the get-go of being capable of raising their child just like the other parent. So that's the presumption. So if you're trying to get away from that, then the burden is then on you to have to show, well, there's this going on and there's that to consider, and then you have to be compelling enough to get the court to buy into that and then move off that presumption. As far as placement goes, it's similar. It doesn't say 50-50 placement, but what it does say is that each party has a right to have meaningful periods of placement with their child, and that could be 50-50. And so if you want to come off that presumption, then again, the burden becomes on you of, well, it can't work for these reasons, and this is why. And so it shifts. But to understand that, hey, this is kind of the baseline we're going to be starting with. And so why don't we try to work around working with that baseline? But if you feel that the baseline isn't going to work for you, then this is some of the steps that you have to go through in order to get off of it.
So what you've laid out for us is, it sounds like step number one is get a good attorney that you trust. Listen to their advice. They're going to give you realistic expectations early on, and you're paying for that advice, so listen to it. And it sounds like, given the presumption in the state of Wisconsin, it's tough to overcome, the presumption of joint legal custody. And although there's not necessarily an exact presumption of 50-50 placement, it's not as though it's common that one parent is going to have 100% placement and the other parent will have 0. Is that fair?
That's exactly fair.
You described this timeline for us, and given the presumptions and the burdens of proof, it sounds like a lot of people may come in originally with a thought of an outcome, but with some good advice and some understanding of what this process truly entails, people may second guess wanting to push through months and months of expensive litigation only to get to an outcome, where a judge is the one making the decision, and that party may in fact be very unhappy with that decision.
One of the things I notice is that when parties come to an agreement on their own, even if that agreement is way different than what they initially wanted from the beginning, they're usually a lot more satisfied, and they're a lot less likely to come back to court or come back and hire an attorney for future custody and placement issues. Whereas when a judge is the one making the decision and there's like a trial and a court order, we then generally see that most people will be returning clients in that sense.
Ideally, you will reach an agreement on custody and placement in your case, finding compromises along the way that you can feel confident are in your child's best interests. The best way to do that is to be very clear with your attorney What are your goals? Why do you have those goals? What's really important to you here? In addition to telling your attorney what you want, it's also being willing to accept what your attorney is telling you. You hire that trusted attorney because you want them to give you expertise. So being willing to listen to them and accept the reality of the law in this state and how that law applies to your case is going to be really important to help you avoid an expensive, time-consuming, drawn-out divorce process in which you may be very unhappy with the outcome in front of a judge. Unfortunately, some cases, despite your reasonableness and despite your attorney's best efforts, will land in front of a judge. That may happen in a small percentage of cases. And when that happens, you need to have an experienced attorney who listened to you throughout the process and who you were willing to listen to throughout the process so that you can try to secure the very best outcome on the most important issue in your divorce.
Go to sterlinglawyers.com to learn more about our attorneys. Please take the time to like, comment, and share. Subscribe or follow us for weekly family law content. Thank you for watching this video with Attorney Mullen and Attorney Keenan.